Hello and good afternoon, everyone. My name is Halley Auger. I'm an employment lawyer in our Calgary office of Samfiru Tumarkin, here to answer any of your employment law related questions. Hopefully we have a busy day today. Last time I was here, we weren't able to get through all the questions, so make sure you get your questions in early and we'll get rolling as soon as they come in. Before we get started, I just wanted to talk to everyone about an interesting conversation I had with one of my clients this morning. And we were finally able to negotiate a pretty generous severance package. The client came to me. He really wanted a 12-month severance package, and his original offer wasn't that high. He had attempted to negotiate with his employer and really knew that his goal was 12 months. He thought 12 months was fair. I met with him. I agreed 12 months was fair. His employer simply just wasn't offering it. And so he did end up retaining our firm, and we were able to negotiate. And, it took a few weeks. It took a few rounds of negotiations, but we did get him his 12-month severance. And I expected to get a very happy client because we got him everything he wanted. But I sensed that he was upset. And I said, what is it that bothers you? And he says, it bothers me that I wanted 12-month severance and I had asked for it and I wasn't able to get it on my own. And, I really empathize with people who are in that situation. Lawyers aren't free. Unfortunately, you get free healthcare, free free, other type of care. But, sometimes you do have to, spend a little money on a lawyer in order to get, what you're entitled to. And my client was highly sophisticated. He was right. His assessment of what his entitlement was fair and reasonable. But sometimes you have to hire a lawyer, and it's not that your employer, doesn't necessarily, it's not that they don't respect you. It's not that they don't like you. It's not that they're trying to hurt you. It's just that lawyers know how to create leverage. Getting a request for severance from an employee is different than getting it, on a lawyer's gold embossed letterhead, with the threat of a lawsuit. Sometimes we do have to start a lawsuit, just in order to create that leverage, to show that you're really serious, to show the employer, if you don't settle here, the writing is on the wall, you're going to end up paying a lot more because you're going to end up paying the severance. You're also going to end up paying your own lawyer and perhaps the employee's lawyer in order to have to get there. So, settle now. So don't take it personally if you have to hire a lawyer. We are here for you. We're happy to help. Just because your employer isn't negotiating with you doesn't mean you're being unreasonable. It just means that sometimes lawyers need to use some of the tricks we have in our toolbox to create that leverage. I also don't want people being afraid of the legal fees. There's lots of different ways that we can structure settlements to reduce income that you pay on it, so that even if you have to pay a lawyer a little bit of money, it actually evens out because the employer or the lawyer is able to employ some of the tax savings structuring. And so, usually we are worth what you pay us because, we get you the amount of money and usually our legal fees are covered in some way or another. All right, so let's get started with some of the questions. Okay. Question from Possession Primary. About 2 years ago, I worked at an office that didn't pay for the first 2 weeks of work. I was young and didn't know better. I want to file a claim now. Would it be too late? So in Alberta and frankly throughout Canada, we do have a 2-year limitation period to file a claim. And so if you worked more than 2 years ago, if your employment period of time that you weren't paid for was before June 19th, 2023, unfortunately, you may be out of time to sue. We have these limitation periods in place, and they're called fatal. That means that no matter how compassionate a court is, to the reason that you haven't filed a lawsuit in 2 years, the courts actually don't have jurisdiction because it's written right into legislation that you have 2 years to file a claim. So if you are within that 2-year period, you can still file a claim. I'm surprised that there are companies that still exist that are not paying people for training. You have to be paid for training. If it takes 2 weeks for you to be trained, that's work. That's compensable work. And so employers have to pay it. So I don't see any reason why you wouldn't be entitled to payment for those 2 weeks, but you could be in danger of being out of time. Now, if you are really coming close to that limitation period, you're really almost at the 2-year anniversary, you may want to reach out to a lawyer immediately if you want a lawyer's help. If it's 2 weeks pay, it's probably going to fall under a small claims jurisdiction. So sometimes lawyers can draft those pretty quickly. They don't take, more than, a few hours of our time to draft and get the information, but you do want to reach out because hiring a lawyer can take, a few days to get the process going. So contact us, employmentlawyer.ca, and we'll see if we can assist. But if you are in danger of that limitation period, quick. The great thing about Samfiru Tumarkin is that our lawyers really are in high demand. And so, if you need us to do something on an urgent basis, we need to be able to fit you in with all the other people who are looking for our assistance. Okay. A question on Facebook from Shepa. Earlier this week, the owner of the company that I work at gifted me tickets to an industry-adjacent event. It runs from Thursday to Sunday, but I can only attend on Friday. To ensure I can attend the event, I requested to use one of my paid vacation days on the Friday. The request was subsequently declined, with the reason being that I already have a Friday in the same month booked off. There's no written company policy that limits the use of vacation days in this manner. Can they still deny my request? So I'm a lawyer. I provide legal advice. Practically, do I think it's silly that your employer is refusing to provide you with the Friday off so that you can attend the event for which they gave you tickets to? That's silly. But under the Employment Standards Code, at least in Alberta, is that an employee makes a vacation request, and the employer can approve or deny that request. And so ultimately your employer, if you're not in danger of, use it or lose it, we're not talking, December 30th, 31st, or end of the year, your employer can deny their request. Now, whether they have a written policy or some sort of practice, or for whatever reason they want to deny your second Friday off, it's the summer. Lots of people want to take Fridays off. And maybe they have other people looking to take the same Friday off and they're managing their workforce in that way. Technically they can. You can make a vacation request and say, I want to use my vacation day this day. You have to. Now, I don't want that to be confused or anybody to extrapolate from my answer that it means that your employer is always allowed to deny vacation requests. No, vacation requests, have to be used during the year in which they're earned, or the year following that they're earned. So you accrue your vacation days and then you're entitled to use them in the next year. So your employer cannot continually deny your vacation requests. You have to be able to use them. But on a one-off, like a particular Friday of the year versus another particular Friday, no. Frankly, the employer can say, no, we want you to use your vacation day next Wednesday. Excuse me. So I'm sorry, Shepa, your employer is being confusing. Give you tickets to an event that they now won't give you time off to attend. But yeah, you're asking a legal question, and the legal answer is, yeah, they can do that. Terrible B, who I think might be a repeat caller. I hope you're a repeat caller. If not, I think it's a great username. Is an employer allowed to withhold wages as a means of punishment? I was asked to take on an extra shift and said I couldn't, and now they don't have my pay and will be a week late. No, your employer cannot retaliate against you. In fact, the Employment Standards Code prohibits them from retaliating against you, from enforcing your rights. Um, yeah, no, your employer has to pay your paycheck. There's certain rules under the Employment Standards Code. I don't know if Terrible is an Alberta employee, but in Alberta, the Employment Standards Code does say that you have to pay, within the time period following the pay period in which the earnings were earned or the wages were earned, and so you have to pay that. I mean, I don't understand an employer who just simply says they don't have it. That's that that would have some red flags for me. Either your employer is on the brink of bankruptcy or your employer is retaliating against you. If there's other issues going on, please feel free to reach out. Terrible. These things don't usually happen in isolation. Usually, employers who retaliate against employees don't do it in just sort of one-offs. They do tend to sort of have a pattern. So please feel free to reach out. Employmentlawyer.ca will do an assessment of sort of the employment situation you have going on there. Okay. Mary Lynn, my brother has been working as a delivery driver for the last few years. His employer forces at least 10 hours of OT, so overtime, on him in a month. Can they make that a mandatory requirement? And can he say no? Interesting. After more than a decade of employment law experience, I don't know how I've been asked this question before. Normally, overtime is not a choice. I mean, it isn't, particularly if your employer is paying for it. You can't be seen as refusing work. But it's interesting if it's, 10 hours in a month and it's starting to be too much for your brother. And, yeah, I mean, he can probably work with his employer and say, I can't work it. Now, I don't know if this is a change or if this has been, every month for every, of the last few years that he's worked there, he's had to work overtime. Your employer isn't really making any change to the employment relationship. And then if an employee is simply refusing to work, potentially the employer could say, that's a refusal and can terminate you. Now, it really is a bit of a hairy issue because it's overtime, and I don't know if there's contractual employment or contractual terms in the employment agreement that require him to work overtime and specifically say this job requires overtime. After a few years of having that be, sort of the history, it could even be an implied term of the employment relationship. In these types of situations, it's great to get legal advice, but sometimes all it takes is a conversation with the employer to explain, look, I'm getting burnt out. I'm working too many hours. Is there anything I can do to sort of get back to working, a standard work week? If your employer pushes back and then, sort of the employment relationship is damaged, certainly feel free to reach out. And we can assess whether there's a constructive dismissal situation going on. Okay, Vanny is asking a question. I started a position with the promise of receiving an increase to my salary after completing probation. Now that my probation is ending, the employer wants to extend it out by another 3 months. Interesting. I have seen this happen before. Employers want to solicit people to work in roles, and so they do put attractive incentives on the table. Say, if you work here, we're going to increase your salary, and it's really induced you to take on that employment. And in fact, it was sort of a representation that was made to you. You may not have taken a job that only paid $20 an hour, but you took it under the promise that was only, during the probationary period, and that, by month 3, you'd be at, earning $25 an hour. So I would have a hard time. I'd probably push back with that employer and say, no, I mean, I took this job based on the representation that the money I was receiving would be X amount of dollars. Um, yeah, I don't know on what, like, employers, this whole idea of probationary periods really stems from the Employment Standards Code. There's a 90-day period where an employer is allowed to terminate you without providing you any notice or pay in lieu of notice within that first 90-day period, and that makes sense. You hire somebody, you're feeling each other out, you want to make sure the relationship works. Um, and if it doesn't, you want to be able to just sort of say goodbye. Now, to say that there are certain entitlements that might kick in after a probationary period, we also see that, with health and dental benefits. And again, that sort of stems back from this idea that we need to sort of feel each other out. But they can't just keep extending a probationary period indefinitely. Employment Standards Code doesn't allow them to do it beyond the 90-day period. So I would absolutely be pushing back on the employer on that, Benny. You entered in an employment relationship based on certain promises. The fundamental promises of an employment relationship are, I do this work for you, and in exchange, you give me this money. That's a deal. A deal is a deal. And this isn't like a bonus or a potential increase, wages that go up from time to time. It sounds like this is pretty explicit. You have a lower rate during a probationary period, but effective day 91, your rate goes up. I don't think an employer has the right to then claw that back and say, we're just going to extend your notice period. Oh, so Vanny's follow-up question is, it seems suspicious. Do I have any options but to agree and keep being underpaid? Well, no. I mean, yes, you do have options. I mean, if you have something in writing that says that they're going to pay you an increased hourly rate after, the 90-day probationary period, you can take that to Employment Standards Code. You can say, I'm not being paid wages. The same thing happens if you're not paid your vacation pay, if you're not paid termination pay, if your employer, kind of like Terrible was dealing with earlier, the employer just withholding wages. That's what the Employment Standards Office is there to do, is to ensure that employers are treating their employees fairly. So certainly you can do that. If you'd like legal assistance, we're happy to help you with doing that as well. Employment Standards Code or Employment Standards complaints, we help clients fill them out all the time. Just give us a call, employmentlawyer.ca. You can also email us at help@employmentlawyer.ca. Oh, Bubbles the Woodle has come to join us for some legal advice. All right. We've got BC Piney. I hope I'm saying that right. My sister is in short-term disability and resigned from work after learning that her long-term disability got denied. Her appeal got approved 6 months later. Could she still rescind her resignation? Interesting. It's an interesting question because it depends on the reason why, she resigned. If she felt forced to resign because she is disabled from working, then yeah, I think she should, return to her employer and say, I only resigned because I had no choice. I am disabled. Which means I'm unable to work. My long-term disability has now been approved, which, establishes that I'm unable to work, and frankly, retroactively have been unable to work. If I'm in a position where I am fit to return to work in the future, I would like to return to my employment. Some employers will work with you on that because they understand the situation, that, you had no choice but to resign as a result of a disability. I mean, the alternative is that you get fired because you're not showing up to work because you are disabled from working. So lots of times employers will undo it. If not, certainly contact a lawyer and we can help undo it, and then have sort of her employment put back in place, with the understanding that, it's just sort of a temporary placeholder because we don't know what the future holds for your sister. Sometimes disability is for people who, even if you're on long-term disability, that doesn't necessarily mean a forever disability. You could be on long-term disability because you're awaiting a surgery date or you're receiving medical treatment. Cancer treatments can take more than, 6 months or a year or even a couple of years. That doesn't mean you're not going to ever be able to work. It just means for, a non-significant period of time, you're unable to work. So certainly if she wants to be able to return to that employer in the future, if she recovers from her disability, then, absolutely contact us and we'll see what we can do. Okay, question from Shayla. I am hiring for a position within my company and I'm concerned due to the makeup of my local area that I will hire someone whose values don't align with my business, even if they otherwise have the qualifications to be a great employee. Am I allowed to ask an interviewee's views on marginalized communities? Interesting. What we don't want is discriminatory hiring practices. So I'm not really sure I understand the question, but if you want to know what someone's views are, uh, like if you want to know if they are discriminatory, if you're trying to suss out if somebody discriminates against marginalized communities because you don't want to hire somebody that discriminates against marginalized communities, is that discriminatory? I don't think so. What we don't want to see is employers who won't hire somebody because they are a member of a protected class. So if you are a member of a minority, if you are a member of a certain religion, gender, sexual orientation, we want to make sure that people are able to participate in the workplace fairly. So, Shayla, I'm not really sure what your question is, but we just don't want to we want to make sure that employers aren't discriminating against people. If you are concerned that you might be hiring employees that do discriminate, how do you get around that? I'm not sure. And I wish I had an answer for you. But, you can always say, like, do you believe in equal opportunity and equal rights? And, I guess that would be a question, but I'm not really sure. I've not really been asked that question before. Okay, Lakin. My contract is due to be renewed soon, but I've noticed we are down on business. If they choose not to renew, do I have any sort of severance owed, or am I out of luck as a contractor? Well, that depends on a variety of circumstances, and so sometimes people are believe that they're a contractor, but they're really a misclassified employee. So for all intents and purposes, they're an employee. They work amongst other employees doing the same duties as employees. They work for one employer. They get paid sort of a T4, they get paid income, like regular income and income taxes withheld. Or, they just sort of, they have no opportunity for profit. They get sort of paid an hourly wage. Then they're really a misclassified employee. And yes, you would be entitled to some notice or pay in lieu of notice, which we refer to as severance. Now, if you are an independent contractor, so an independent contractor is, for example, like a mechanic who works on a lot of different people's cars. Or if you are a person who cleans houses and you clean, for lots of different people, you're an independent contractor, then you're not entitled to any notice or pay in lieu of notice. And then sometimes you are a dependent contractor, which means, there are things about you that make you like a contractor, but that you are financially dependent on one single, principal or employer, I use that term loosely, for all of your income. In that case, you may be entitled to notice, but it really depends on the province you're in. In Alberta, a dependent contractor is treated like a commercial relationship. And if you have a written employment agreement, a written contractor agreement that says how much notice you're entitled to, 30 days, and they can terminate you, our courts enforce those. So you're really going to want to have a lawyer look at the terms of your contract, particularly if your contract gets renewed over and over and over again. Have an employment lawyer look at your contract and see if there is an enforceable termination clause in there. It also turns on what the like how many times it's been renewed, if this is a really long-standing relationship or if this is the first renewal, and terms on what your contract would say about the ability to renew and what has to happen in order for it to renew. Okay, gone. My employer is based in the US. They often require us to take US holidays and not the Canadian ones. Should we receive time and a half for this, or lieu days, or anything? Yeah, so if you are a Canadian, you're entitled to statutory holiday pay on the Canadian statutory holidays. If they are requiring you to take US holidays, they better be requiring you to take Canadian holidays as well, or they need to be paying you, for you're working on a statutory holiday. Your employer can require you to use your vacation days to take off the US holiday days. But they can't just say, well, you don't get a Canadian Thanksgiving off because we give you US Thanksgiving off. That's not the way it works. They can have you use your vacation day for when you take US vacation off. But if they're making you work on Canadian Thanksgiving, they have to pay you double time and a half. So that's a great question. It doesn't come up frequently, but I've actually seen it in my experience before. It does happen. U.S. companies think that their Canadian employees should sort of follow their holiday. I mean, it's only a few differences between the two holiday systems a year, but it's enough. I mean, July 4th versus July 1st, our Thanksgiving versus their Thanksgiving. And yeah, I don't think it's fair that you would be, required to work on a Canadian holiday so that you could have an American holiday day off. Okay, Joey. I was discriminated against for being queer at my place of employment. And because I waited more than a year, I was told there's a statute of limitations for workplace discrimination. Is that true? Yes. So even though we have 2 years to file a lawsuit, our human rights legislation has a 1-year statute of limitations. Really, I think the reason for it is our government really wants to make sure that discrimination does not occur in the workplace. We have a vested interest in ensuring that people are not discriminated against. And if discrimination is going on, the Human Rights Commission wants to know about it. So that it is only a 1-year limitation period. And so even though the Human Rights Commission can look at discriminatory actions that occurred, more than a year ago, they can't really consider that in a finding of discrimination. The discriminatory event would have to occur within the 1-year period. Now, there's some exceptions, like if you've filed a human rights complaint, but in the wrong jurisdiction. So you filed under the, Canadian Human Rights Commission instead of the Alberta Human Rights Commission, there could be an exemption. If you tried to file your complaint, but it got rejected because you were missing information, and then they give you another, month or two to sort of fix it up, they can extend it that way as well. But other than that, those are the 1-year limitation periods. Now, if you want to file a lawsuit against your employer, you can still allege that you were terminated without, reasonable cause, without just cause, and you're entitled to termination pay, and you can sue for bad faith damages as a result of the manner of termination. So sometimes discriminatory acts are also bad faith acts. Feel free to reach out, employmentlawyer.ca. All right, everyone, it was a pleasure speaking with you. I'm Halley Auger at Samfiru Tumarkin in the Calgary office, and I'll see you again in a couple of weeks. We're next here on Friday with Dan Balcaran of our Vancouver office. So for all you BC folks, make sure you give Dan all your juicy questions. Okay. Take care. Bye.